My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action, we have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
You know, the previous module was dealt with the issue about the rationale for treating a cause such as this, the issue of rights of persons under detention and prevention of torture. For this particular module we're dealing with now, we will be looking at the rights of detainees and prisoners or inmates in relation to physical integrity.
My brother, we were told about your case by an anonymous worker here. So can you tell us what really happened? What's the matter?
I'm a victim of a thing I don't know.
Tell us.
But before I continue, I beg, who will I be?
We are activist lawyers. We deal with cases related to injustice on citizens.
Thank you. Now, one faithful morning, when I dey go work, when I come see one police car, it come direct to my side. Before you know, the policeman jump down.
And so?
Before you know, the same enter their car.
This is funny, but continue.
When I enter the car, I can see some of my colleagues who they work together. The thing surprised me. I can ask, what thing are you doing inside police car.
Okay. Now, at the police station, what happened when you got there?
For the police station, they don't tell us what to do. But I overheard them, they talk, say, one matter of burglary for our own workplace.
Okay.
They can't say, make we bail ourselves for 5,000 naira each. Which I no get that kind of money. We no agree, oh. But later now, 3 guys, we get the money, they can't bail themselves. Come out. It can't remain only 5 of us. 3 guys, 2 ladies. Inside 5 of us, one of the police oga, he carry one of the lady. He carry her go house. He go free her. He can't remain only 4 of us.
Wait. You mean the ladies and the guys were inside one cell?
No. The guys were there inside cell, while the ladies they counter. But the station small sha. We feed the inside, they see them. And all the things they discuss, we dey hear them.
Okay. Then what happened later?
The remaining 2 guys who dey with me, their brother come with barrister. He come dey threaten them. So he go carry this matter go court.
So, you mean the DPU was not even aware of all this?
The DPU. Now the next day, the DPU come work. He come ask them of update. They come present me to the DPU. He asked me wetin happen. I explained to the DPU. He come check register. I no dey register. He come make am no believe me for all wetin I dey tell now.
So have you been charged to court? Do they take you to court all this while?
Now once, and na 2012, on top the same matter, come make my own mother die because of heartbreak. She no get who go help me.
My brother, this is how innocent people suffer for nothing. But don't worry. Don't worry. We'll take up your case. Take it easy.
Now, what is the lesson objective for this Model 2? The lesson objective is to create awareness on the various rights of detainees and inmates in correctional facilities or other detention facilities as pertaining to international, regional, and national laws in relation to their rights to physical integrity. What do we expect that you, as a police officer who have actually decided to take on this course, what is it that we expect you to do or have at the end of this course or this particular module? It is expected that you will be able, after the training, to increase your knowledge on what constitutes the rights of detainees, as well as how you can actually deal with these, protecting these rights, observing these rights, especially in relation to physical integrity. Now, the first, when we talk about rights of physical integrity, first is about arrest and detention. Persons under detention, please note this very carefully. Note this very carefully. Persons under detention are entitled to their fundamental human rights. Fundamental human rights in relation to right to life, right to dignity of human person, right to fair hearing, right to freedom from discrimination, and many others. These rights should also be promptly communicated to the person who you have arrested or you have detained. This is very, very important. The UN Body of Principles for the Protection of All Persons under Any Form of Detention and Imprisonment, specifically Principle 13, states as follows. It says that a person shall, at the moment of arrest and at the commencement of detention or imprisonment, or promptly thereafter, be provided by the authority that is responsible for his or her arrest, detention, or imprisonment, respectively, with information on and an explanation of his rights, his or her rights, and how to avail himself or herself of such rights. Now, listen very carefully. The only right that the arrested or detained person is excluded from enjoying is the right to personal liberty. And remember, the important thing is that at that point of arrest and detention, you should be able to do what? Make their rights known to them. Make their rights known to them. And you would see that this is clearly provided for, both in the Nigerian Constitution, both in even the Administration of Criminal Justice Act 2015. Now, what is the important thing to look at here? One is freedom from arbitrary arrest and detention. No one, I repeat, no one should be subjected to arbitrary arrest or detention. This particular point, you will see it under Article 3 and under Article 9 of the Universal Declaration on Human Rights. In addition, you will also see it under Article 9 sub 1 of the Covenant on Civil and Political Rights. Even the African Charter on Human and People's Rights, specifically Article 6, speaks to this same issue. Ultimately, arrest must always be subject to judicial control or supervision. Please note it. Arrest must always be subject to judicial control or supervision to ensure that it is very legally applied, meaning it is applied in accordance with the provisions of the law. Do not also forget that accurate record of arrests should be kept for effective judicial supervision, and in case there is any issue relating to disappearances or, allegation of such. Principle 12 of the Principles of on Detention speaks very clearly about it. So please, what this is saying is that you should not have documents or loose forms for recording maybe people who you are arrested on Friday, and maybe by Monday, some of that information is not reflected. Let me tell you, even the Universal Periodic Review, during the Universal Periodic Review, some of the recommendations that were made to Nigeria was also speaking on this same issue. Nigeria was told to make sure that in terms of arrest of persons in every place of detention, that this must be entered in a tamper-proof register. A register that cannot be, mutilated or not, so that at any time, somebody can come in and find out on so date, on so time, who were actually in the places of detention. Don't forget that. Now, I will also encourage us to look at Section 35, specifically subsection 1 of the Constitution of the Federal Republic of Nigeria, 1999. What does it say? First, it says, every person shall be entitled to his personal liberty, and no one shall be deprived of such liberty except in the cases and in accordance with a procedure permitted by law. A. He says, in execution of the sentence or order of a court in respect of a criminal offense in which he has been found guilty. B. By reason of his failure to comply with the order of a court or in order to ensure that the fulfillment of any obligation upon him by law. C. For the purpose of bringing him before a court in execution of the order of court or upon reasonable suspicion of his having committed a criminal offense, or to such extent as may be reasonably necessary to prevent his committing a criminal offense. D. In the case of a person who has not attained the age of 18 for the purpose of his education or welfare. E. In the case of persons suffering from infectious or contagious disease, persons of unsound mind, persons addicted to drugs or alcohol or vagrants for the purpose of their care or treatment or protection of the community. F. For the purpose of preventing the lawful entry of any person into Nigeria or of effecting the expulsion, extradition, or other lawful removal from Nigeria of any person or the taking of proceedings relating thereof, provided that a person who is charged with an offense and who has been detained in lawful custody awaiting trial shall not, I am repeating that for the third time, shall not continue to be kept in such detention for a period longer than the maximum period prescribed for the offense. The above provision, if strictly complied with, will prevent arbitrary arrest and detention. But also, it means that anything outside the remit of what we have seen here under Section 35 sub 1 is arbitrary. Okay? Now, what is the second thing we must take note? Right to be informed of the facts and grounds of his or her arrest. If you look at both Section 35 sub 3, that is clearly given. Even if you look at also Principle 10 and Principle 13 of the body of principles for the protection of all persons under any form of detention or imprisonment, which you can also see it. In terms of that principle, this was adopted by the United Nations General Assembly in December 1988 under Resolution 43/173. Now, quickly, I'll just tell you. Section 35, sub 3 of the Constitution of the Federal Republic of Nigeria says, any person who is arrested or detained shall be informed of in writing within 24 hours and in a language he understands of the facts and grounds of his arrest and detention. So, the notification of reasons for arrest is very, very important. It relates to two stages notification. Notification first of the reason for arrest and charges related to this. Okay? Now, apart from that, we must also begin to look at what is the provision in Article 9 sub 2 of the Covenant on Civil and Political Rights. This involves, the whole issue and rights that these persons that you may just have arrested on the road, you need to, sometimes you say you arrest and say, what is it that we have done? Come on till we get to the station. And sometimes even up to 24 hours will pass, they won't be informed. So please take note of this provision. The person must be informed of the charges that are brought before them, and not just informing them, ensure that they understand it in a language that they understand, in a language that they understand. Let's look at another issue. The other issue is the whole notion of presumption of innocence. I mean, I hope you will relate very well with that, because if the time somebody comes in and say, oh, that armed robber, that bully, and you already, remember, you are not the court that would declare it. Your own job is to bring together the body of evidence that is able to prove the charge that you are bringing forth, and that will enable the court to so declare or convict such a person, and then so award the sanction. Presumption of innocence. Pre-trial detainees have the right to be presumed innocent until proven otherwise. We know that. Okay? They have that right to be presumed innocent until their guilt have been proven according to law. The Universal Declaration of Human Rights, especially Article 11, sub 1. Also, the Covenant on Civil and Political Rights, if you look at Article 14, sub 2, it is saying the same thing. Non-convicted persons are guaranteed the right for separate treatment. We should see that is appropriate to their status. And what is that status? Status of being deemed innocent. The standard minimum rule speaks on this issue. If you look at Rule 86, look at Rule 87, look at Rule 88, even Rule 91 of this standard minimum rules is speaking on the same thing. If you also look at another point, which is the issue of right to remain silent, and please, I really need to stress this point. How do you react to someone who said is exercising their rights to remain silent? Or someone who says, I'm waiting for my lawyer to come. It's not the time for you to beat and smash them and say, when I touch you, you will then be able to know whether you will speak or not speak. Any person who is arrested or detained shall have the right to remain silent or avoid answering questions until after consultation with their legal practitioner or any person of their choice. Go and look at what Section 35 sub 2 of our Constitution of the Federal Republic of Nigeria, 1999 says. So the issue, yes, I can understand some of the frustration you may have. You want to quickly end up the case. You want to quickly, get your evidence. You want to quickly get the person to confess or, or something like that. Don't worry. The issue here is that if you have done your due diligence in terms of investigation, you will be able to get factors that will help you collaborate issue. That the fact that you wait a little while does not mean that you will not be able to still nail this particular person if indeed he or she are guilty of the offense that you are charging them. The fifth point I want to flag here is the issue of the right to be brought to court within a reasonable time. Section 35 sub 4 of the Constitution of the Federal Republic of Nigeria says that any person who is arrested or detained in accordance with subsection 1C of that same section shall be brought before a court of law within a reasonable time and tried with a period of, first A, say 2 months from the date of his arrest or detention. In the case of a person who is in custody or is not entitled to bail, or B, in 3 months from the date of his arrest in the case of a person who has been released on bail. Please note that two differences. The first is 2 months in the case of a person who is arrested or detained and who is still in custody but is not entitled to bail. Whereas the second scenario is 3 months for someone who has already been released on bail. And that person, has to also be able to meet certain conditions necessary to ensure their appearance for trial at a later date. The expression "a reasonable time" was also defined in subsection 5 of the same section 35 of the Constitution. And what does it mean? It says, in the case of an arrest or detention in any place where there is a court of a competent jurisdiction within the radius of 40 kilometers, a period of 1 day. Period of 1 day. 1 day, 24 hours. If the location where the person is being detained and the next court of competent jurisdiction is not more than 40, it's within a 40-kilometer range, radius, okay? And the B is, in any other case, a period of 2 days, that is 48 hours, or such longer period as in the circumstances may be considered by the court to be reasonable. The question is that those people who you are keeping in the detention, for how long are they in your detention? Are they in compliance with section 35 sub 5? Now, if you don't know that it is against the law, indeed, it is against the Constitution of the Federal Republic of Nigeria. Now you know. So what then can that mean to us? It may mean that we should make sure we do everything possible. Get enough information, get enough evidence that by the time you are now arresting the person, you are ready to take the person to court. So that you do the needful. Now let's look at the sixth issue. The sixth point that is flagged here is the rights of the detainee to have access to a lawyer. The detainee's right to access to a lawyer of his or her choice is firmly established under international law. This safeguards, protects these rights. There are clear safeguards that protect this basic due process right. And it's enshrined in many laws. So I give you some examples, just some few. If you look at the body of principles for the protection of all persons under any form of detention and imprisonment, specifically check principle 18 and then check principle 33 sub 1. It's clearly written here. Detainees have a right to full and unrestricted access to a lawyer of their own choice, as recognized by the United Nations Basic Principles on the role of lawyers. National authorities are obliged to ensure effective and equal access to lawyers for all persons within their jurisdiction. Please, this is really important. And when you look at some of these provisions, and you will look at your slide, you will look at your manuals to understand how this really plays up. But we know that even the Legal Aid Act of 2011 provides that this needs to be done in case the person doesn't have enough money to pay for it. So it is important to use those platforms to be able to say, okay, if the person does not have a lawyer, you can, as a police officer, contact the Legal Aid Council office and then say, please, we have somebody in our detention and we require this support. Don't forget, Legal Aid Council of Nigeria is the national institution, is the institution in the country that is supposed to provide this service. And hopefully, I know many persons, including civil society organizations, including lawyers, are providing also pro bono services. So please, let us ensure that this is really dealt with. And you can also look at Principle 8. If you look at the Principle 8, you will see where it's stipulated that government should ensure that lawyers are able to perform their professional functions without improper interference and can consult with their clients freely without delay and interception or censorship and in full confidentiality. So instances where we hear that the police officers slap lawyers, please, I believe after this course, such shall not be heard, certainly not by you. So you cannot be one of the police officers that they would say slap lawyers, because you know that they are exercising their professional duty. They are working in line with both what the Constitution of Federal Republic of Nigeria states and what international covenants have also promoted. If you look at the UN body of principles for the protection of all persons under any form of detention or imprisonment, you will see there that it stipulates that the right to consult and communicate without delay or censorship and in full confidence with legal counsel save in exceptional circumstances such as that will be specified by law or in the authority, through lawful regulation, when it is considered that this is indispensable by judicial or other authorities in order to maintain security and good order. What am I saying here? This principle is saying the only time where you may stop or delay that contact, that immediate contact between the lawyer and the detainee is only when in law, when it has been specified by law or through a lawful regulation, said clearly by any judicial authority or other recognized authority that we need to prevent it because we want to maintain security and good order. In any other case, you are not supposed to stop this. So this is very important. I also want to bring to your knowledge that the United Nations Special Rapporteur on Torture stresses that access to a lawyer should be prompt and that the lawyer should be independent from the state apparatus. However, in exceptional cases where it is contended by the state national authorities that prompt contact with a particular lawyer might raise genuine security concerns, and where restrictions of such contact is judicially approved, the detainee should be permitted to meet with an independent lawyer, such as one recommended by a bar association. I hope you understand the point here. So these are only the times where there should be exception to them having access to a particular lawyer. So please, if there is nothing dealing with this contradiction or this principle, that it has not been stated in law that such has to happen, make sure that they have access. And as I said, access to a lawyer means that that lawyer would also has a consideration of the quality, and I think I need to stress this a little bit, because somebody can have access to a lawyer, but that lawyer is not diligently dealing with this issue. It is not your problem, but the point is that when such is there, you can also report. There is a way you can process that you need to make report. You can report to the legal aid council, you can report to the Nigerian Bar Association. They have the disciplinary procedures that can deal with it. So, but the important thing is, let there be access. If they can't pay for those lawyers, make sure that you notify the Legal Aid Council of Nigeria. Now, there is also the point about rights to fair trial. I'm not going to speak much on this, but I want to just refer you to Article 10 of the Universal Declaration on Human and People's Rights. And you can also look at Principle 30 sub 2 of the body of principles for the protection of all persons under any form of detention and imprisonment. Now, look at these things to know that these rights are all enshrined. You will also see that the Covenant on Civil and Political Rights speaks also about this issue, especially Article 14. Okay, let's look at another point. Okay, now, beyond what we have said earlier, there is also the whole issue of admission and release, the rights relating to that. First, persons deprived of their liberty should be held in places which are officially recognized as places of detention. Don't keep them where it's not legally identified as places of detention. You will look through, you will see that there are several provisions supporting that, including Principle 6 of the principle of the effective prevention and investigation of extrajudicial, arbitrary and summary execution. I'm not going to go much into that detail, but you will see those in your manual. Take time and read it. So I'll mention another point under this. So let's go on. Now, the other one is about the issue about having a detailed register, and this should be kept, for every person who is in the place of detention. I have hinted a little bit around this, but look at Article 10, paragraph 3 of the Declaration on the Protection of All Persons under Enforced Disappearance. You will see all the things that he have mentioned there. Even if you look at the standard minimum rule, especially Rule 7, you will see how he stated it here. He said that in every place where persons are imprisoned, there shall be kept a bound register book with numbered pages in which such be entered in respect of each of these prisoners. And when you look through, you see what is stated there in terms of the identification of who they are and the rest of it. Let's look at another issue. It's about a prisoner shall be provided promptly with written information about the litigation which apply to their treatment and about their rights and obligations. They should know what are the do's and the don'ts, what they shouldn't do and what they should do. Look at also Rule 35 of the United Nations Standard Minimum Rules for Treatment of Prisoners. That will give you some information around that. Let's look at the next one. Access to the external world. Rule 44 sub 1 of the Standard Minimum Rules for the Treatment of Prisoners, and also Rule 92 speaks about this issue. So please remember that they are entitled to have contact with the outside world, their families, their friends. So it doesn't mean that you will not take on the due process, but please do not deny them of this right. Let's look at all the other things. The issues about families, legal representatives, and if appropriate, diplomatic missions of the detainee are to receive full information about the fact of their detention and where they are being held. If you go through all the things that have been stated in your manual in relation to Principle 13 of the Body of Principles for the Protection of All Persons under any form of detention or imprisonment, you will see it where it is clearly mentioned. And please, as I have said, take time, because once you can understand this very well, you are able to apply it in real life. You're able to apply it to your situation. And I believe that after this training, there are a lot of things that you will begin to do to comply to some of these human rights principles and standards. Yes? A prisoner shall be offered a proper medical examination and treatment as soon as possible after admission. Please check that, because it won't be good to see that they are dead in there. The same thing, your detainees, once they're there, please make sure that they have access to treatment. If you see them sick, if there is a wound or whatever it is. So please, it is very important. Don't forget what your function is as a police officer, okay? So please ensure that you do the right thing. They also have rights to not to be compelled to testify against themselves. Note this also. They do have that right. And specifically Article 15 of the United Nations Convention Against Torture, Cruel, Inhuman, and Degrading Treatment states this very clearly. You can see that also in Principle 21 of the Principles on Detention. It says no to torture. On no occasion should torture be used. Yes. Now, there are core principles. I encourage you to look at them. Apply them and make a difference in how you prosecute and how you deal with people following this training. All persons deprived of their liberty shall be treated with humane and with respect to dignity and of their person. Please look at all these things we have studied, review them, and apply them. It's not just enough to know them. It is better when you can apply them, because it will make you a better officer.